Good afternoon, everybody, and welcome to this session on legal issues for management. This is another week when we are going to be talking about some concepts in legal issues for management. Today, we're going to be talking about contract law. Contract law is very important to you as a student of business management, because in the course of your career as a business manager, you will be involved in signing a lot of contracts on behalf of your organization. Apart from that, in your individual life, you will be involved in various types of contracts. So it is important for us to understand the law of contract. So at the end of today's session, you will be able to understand the requirements of a valid contract. You will understand terms of a contract. You will understand how a contract can be voidable. Then we will talk about how to discharge or terminate a contract. Then we look at various remedies, and then just general overview of key contract laws on contract law. Now, what is a contract? So a contract is simply a legally binding agreement between two parties for the purpose of carrying out some business obligations. So it must be a legal issue. For example, you cannot enter into a contract with someone for the purpose of carrying out a crime. So it must be legal. And then when the agreement is breached by someone, it is enforceable by law. So when agreement is breached by somebody, so the law is willing to enforce the terms of the contract. So it's simply an agreement between two people coming together for the purpose of carrying out an action that is recognized by the law. Now, for a contract to be valid, there are basic ingredients that should be involved. One of them is offer. Another is acceptance. The third one is intention to create legal relationship. And the fourth one is consideration. And then we have another one called consensus addendum, which is mutual agreement. But in this class, we shall be looking at offer, acceptance, intention to create legal relationship, and consideration. Now, contracts are important for various reasons, because in every agreement, especially in business, contract helps us to establish the rights and responsibility of individual. It's also a way of managing the economic risk attributable to individual. They help to provide for what should happen if contracts go wrong. How do we form a contract? A contract can be formed just by a simple agreement between two people. It may be written. It may not be written. You can form a contract orally, and it can also be implied from the conduct of the parties. So it can be written, it can be unwritten, and it can be implied. So we have written contracts, oral contracts, and implied contracts. So you must understand that there are three major ways by which you can form a contract. Now, we said that there are basic ingredients of contract. One of them is offer. What is offer? Offer is simply a promise made by an offeror. An offeror is the person that's making a promise to be bound to a contract provided that certain specified terms are accepted. So somebody is saying, okay, if you accept these terms, then I am bound by this term. That is offer. It's a promise. So every contract is based on an initial promise by the offeror to the offeree. Offeree is the person to whom an offer has been made. And the offeror is saying, okay, if you accept my terms and conditions, then I will be bound by doing certain things for you. And one thing you must know about offer is that offer can be made to an individual and it can be made to the whole world. We call it unilateral offer, as in the case of Carlin versus Carbolic Smoke Ball Corporation in 1893. Where it has been decided that an offer can be made to the whole world. Then we must understand that there's a difference between offer and invitation to trade. Invitation to trade is actually an offer to somebody to make, it's like an invitation to people to propose an offer, not really an offer. So we must understand the technical terms. Also, a counter offer cannot be regarded as an offer. Okay, we'll talk about counter offer later in this. So after there's an offer, there must be an acceptance for an offer to be valid. So an acceptance is simply a communication of the offeror, of the offeree to the offeror, that he has accepted the terms and conditions provided in the offer. So the person to whom an offer has been made, saying that, okay, I am able to comply with the conditions of this offer, is called acceptance. Now we must understand that acceptance must not change any of the conditions of the original offer. An acceptance cannot change any addition or any of the conditions of the initial offer. Therefore, an acceptance cannot introduce a new condition to the offer. So when an acceptance introduces a new condition, it becomes a counter offer. For example, I've proposed to sell my phone to someone for £500. Okay, if you give me £500, I'm going to sell my phone to you. I said, okay, I want to have your phone, but I will be willing to pay you £300. You have actually accepted to buy my phone, but you have not accepted my offer. You have made a counter offer, now asking me to receive £300 instead of the £500 that I proposed to you. So you must understand that a counter offer is not an offer. You can see the case of Hyde versus Strange of 1840 for that. Then how do we communicate an acceptance? When does an acceptance becomes valid? So an acceptance becomes valid immediately it has been communicated to the offerer, not when it is accepted by the offerer. It is not when it is received by the offerer or offerer. So an acceptance is communicated. It is when it is communicated by the person accepting that offer that it becomes valid, not when it is received. And that take us to what we call postal rule. Now, if you look at the case of Adam versus Linsell 1818, it was established that if we send an acceptance by post, the acceptance does not become valid on the day the offeror receives the acceptance. Rather, it becomes valid on the day that the acceptance was sent. And this is a bit tricky for the purpose of asking questions. Now, if you compare this with revocation of offer, which I think we'll talk about later, a revocation of offer becomes only valid after it has been received by the person to whom the offer is made. So it is important for us to understand all this legal technicality, which I may be explaining further when we have a face-to-face class. So how do you call an offer to an end? So An offer can be revoked anytime by the person proposing the offer. If I say I want to sell my phone to you for £500, which is an offer, I can say, oh, I'm sorry, I don't want to sell it to you again at any time. So we have to understand that. Then the offer will come to an end if the person I'm making the offer to refuse the offer. Refuse the offer. Then a function of time, we call and we make an offer to come to an end. For example, if after a reasonable period of time, an offer ceases to exist. What is reasonable is dependent on the circumstances of a particular situation. Then upon the death or insanity or lack of sound mind of any of the party, an offer can come to an end. In every contract, that's what we call conditions, terms of contracts. Terms of contracts are made up of two basic things. We have what we call a warranty and condition. Condition are those things that goes into the art of the contract. They are very important to the contract. So let's talk about intention to create legal relationship, which is another ingredient of a valid contract. We've talked about offer, we talk about acceptance. So now we talk about intention to create legal relationship. It still means that the relationship between these two parties must truly be legal. And it has been established in the case of Balfour versus Balfour 1919 that agreement between friends, family members may not actually be construed as a contract in the eye of the law. Indeed, a wife who has sued the husband for promising to make a payment to give her some money was unable to get judgment on the ground that it was not an intention to create a legal relationship. We have two types of contract. We have contract by deed and simple contracts. Contract by deed are contracts that are signed, they are written, they are signed, and they are sealed. And simple contracts can be in form of oral contracts. They can also be written in simple language. There are certain contracts that law requires they must be by deed. For example, any contract that has to do with leasing of property must be by deed. Consideration is the benefits, which is another ingredient of contract, is the benefits that a party derives by going into a contract. And it's what a party is willing to part with for going into a contract. For example, if I say, I want to sell my phone to you for £200, now the £200 you are paying me is consideration to me. My phone that I'm giving to you is consideration to you. So it is the benefits that an individual enjoys by going into a contract. There are a lot of rules that get consideration. One of them is that they must just be sufficient. They don't have to be adequate. And they don't have to be something that has been done in the past. So those are the rules that guide consideration. Like I talk about various types of contracts. I've talked about warranty and condition. Warranty is just a particular term in a contract that a breach of it may not lead to the termination or revocation of the contract, but it gives the aggrieved party the right to sue for damages. But in the case of condition, a condition is a very fundamental term in the contract that goes to the heart of the contract, such that the breach of such a term can lead to the termination or the revocation of such a contract. So what is voidable contracts? Voidable contracts are simply contracts that the law will not be able to enforce. And there are a lot of them. For example, any contract that is made based on misrepresentation will not be enforced by law. You lie to somebody to create a contract, then it will not be enforceable. It's a voidable contract. Any contract that is based on mistakes will not be enforced by law. Contract made under duress. Contract made under duress. Somebody is forced to make a contract will be voidable before the law. And any undue influence. There are situations whereby undue influence has been established, like in the case of an employer to an employee, spiritual person to the followers, a teacher to the student. There could be element of undue influence. So any contract that has element of undue influence will not be enforceable in the court of law. Okay. So how do we discharge a contract? One, by performing the contract. Once each of the party has performed their role of the contract, then the contract can come to an end. By agreement of the party, that's another way. If the two parties decides that we want this contract to come to an end, then it can come to an end. By frustration. Frustration could be as a result of some activities becoming illegal by the virtue of law, or it is practically impossible to carry out the requirements of the contract. It can become terminated. By breach, when somebody has breached the contract, most importantly, if it's a breach of condition, it can lead to the cancellation of the contract by the other party. Now, if there's a breach of contract, the aggrieved party can take the following remedial actions. One, it can sue for damages. Sue for damages for the breach of contract. Then it may request for specific performance as the court to force the other party to perform. There may be an injunction from the court, and then there may be a repudiation whereby the party refuses to carry out any action. So this is all we have got to learn today under the law of contract. There are a lot of things you still have to know regarding, especially about the judicial precedent, different cases that could be applied under the law of contracts. So you are advised to go through these cases. They are available on the module for you. Check them and see how you can apply this in your study. What have we discussed today? One, we have defined what is a contract. Two, we have considered the various elements of a contract. Number three, we have looked at conditions. We have looked at conditions and warranty of generally terms of contracts. Number four, we have looked at how a contract can be terminated. Then five, we have looked at the remedy that somebody who's aggrieved can take if he feels his right has been trampled upon in the course of contracts by breach of contract condition or warranty by another party. Thank you so much for listening. See you next week.